Okay, well then, usually I say good morning, good afternoon, good evening, but I think for everybody in the room and everybody who's participating remotely, it's a good morning or a good very early morning. Welcome to today's event, Reawakening Digital Trade Part 2, the future of the Transatlantic Data Privacy Framework. My name is Lars Steffen. I'm Director International at ECO, Association of the Internet Industry, and I will be your host for this morning. And I'm really glad to see that you are joining us in person today, this morning, although it's Sinterklaas today. I'm married to a Belgian, so I know what it means, and I really appreciate that you are here in this room this morning. And let me get back to the topic of this event. In March 22, the United States and the European Commission agreed in principle to work on a new transatlantic data privacy framework. And this new framework is intended to foster transatlantic data flows and addresses the concerns raised by the European Court of Justice and the Schrems II decision in July 2020, and will finally replace the long now defunct Privacy Shield. This roundtable in Brussels this morning is part 2 of a double event, and we are holding it together with our US partner association, the Internet Infrastructure Coalition, also called I2 Coalition, represented this morning by David Sneed. Welcome. And considering the executive order presented by the US President Joseph Biden in October this year, and the members of both organizations represent internet infrastructure providers at all sizes, from small and medium businesses and also to the so-called big tech companies. And Alexander is this morning representing the ECO Association. And the first roundtable discussion that took place on 6 October in Washington, D.C., organized by our colleagues from I2 Coalition, was also a very good panel with high-quality speakers, including Ruth Berry from the Bureau of Cyberspace and Digital Policy in the U.S. Department of State. We had Kate Charlotte in the room from Google. We had Catherine Steeler from Creative Commons, Alyssa Starzek from Cloudflare, David, and in Washington, ECO was represented by Oliver Sume, the chair of the board of the ECO Association. And what was very interesting for that panel discussion was the day after we learned that there is the new executive order that was published on the new Transatlantic Data Privacy Framework. So, and with the publication of this executive order, the ball is now in the court of the European Commission. And therefore, we are very happy to have Ms. Geneviève Tude with us this morning. And she is head of cabinet of the Directorate General for Justice and Consumers at the European Commission. And she will give us a brief overview of the status of work and negotiations around the privacy framework. Hopefully, she will also have a few insights in the Commission's view on the executive order presented by Joseph Biden and where we are at with moving forward. After this lightning talk, we would like to discuss different aspects of the new framework, and we have a number of wonderful panelists here today for a very exciting conversation about our feelings around the forthcoming framework, and we would like to see what we believe is important. So next to Ms. Tude, we have this morning Ivona McGowan with us. She is participating remotely. Maybe you could switch on your camera that we can also see you. And in the room, we also have with us this morning Corinna Schulze. She's Senior Director, EU Government Affairs at SAP. David Sneed, as I already mentioned, and last but not least, Alexander Rabe. And thank you for being here and joining us today on a Sinterklaas morning. Before we start, we have microphones in the room. If you would like raise a comment or ask questions, please feel free to do so. Also, if you're participating remotely and would like to add comments or questions, please feel free to raise your hand or use the chat functionality of Teams. And please be aware that this session is being recorded and that the recording will be made available later on the websites of both organizations, I2 Coalition and ECO. And with this, I would like to give David, as one of the co-hosts, the opportunity also to welcome the participants, and also Alexander afterwards.
Sure. Thank you, Lars, and I'll be very brief. The I2 Coalition really appreciates the opportunity to continue to discuss privacy and privacy-related issues. Privacy is something that is central to the I2 Coalition's message and our focus, helping our members understand, both from a US and EU perspective, how data flows are regulated, and help lawmakers and policymakers better understand our organization's perspective, and those of our members is particularly important. So I appreciate this opportunity.
Thank you, David.
Also, very warm welcome from my side. Alexander Raab is my name, Managing Director, as already introduced by Lars. Thanks, Lars, for organizing this event in the early morning. And thank you for participating today to talk about this for us, very important topic. We, as an association of the internet industry with over 1,100 members, are essentially touched by this regulation right now and the situation. Legal uncertainty is never good for business, so it makes for us completely sense that we get now into a dynamic situation to work with the executive order we received by President Biden. And as you already mentioned, when we have been there in Washington on the 6th of October and discussed with you, David, it was really tension in the room. We were waiting, and one day later, we received the presidential order, the executive order, and we've seen all the efforts which were made with this executive order. So let's discuss about what will be the future of this framework, and I'm happy that you're here and we can discuss about that. Thanks a lot.
All right, thank you very much. So let's dive into substance. To kick off the conversation, I would like to ask Ms. Füth to give us a level set on what is expected about the data privacy framework, so that everybody in the room can have an informed as possible discussion with you and with us about what we are going to hear in the coming days. The floor is yours.
Thank you. Thank you very much, Lars. It's a pleasure to be with you today, this morning. I would like to thank the organizer for inviting me to take part of this round table. So my name is Geneviève Füth, as you said. I'm Didier Reynder's head of cabinet in the Commission. Didier Reinders has been the lead negotiator, the chief EU negotiator with the US for the negotiation of the successor to the Privacy Shield. So, of course, he was assisted by an excellent team from DG Justice in the Commission. And as head of cabinet, I have the pleasure and the privilege also to be personally involved in these negotiations. So, first of all, let me just clarify that my intervention today is on a personal basis. I will express my views and not the views of my institution. That being said, I would like today maybe to briefly explain, first of all, where we are with the development of the new transatlantic data transfer framework, what the adoption of the executive order by President Biden means for this process, and what the next steps are on our side. So you will remember the 7th of October, you were very excited the day before. I understand that President Biden signed a new executive order on enhancing safeguards for United States signals intelligence activities. This is the long title of this new executive order. The order was complemented by a regulation adopted the same day by the Attorney General Merrick Garland. So together, these two instruments translate into a US legal language the agreement in principle that you mentioned, Lars, that was announced in March by the two presidents, President Biden and President von der Leyen, in Brussels. I remember very well this press conference. We were also very excited at the moment. So the executive order is the result of intense negotiations that we had starting in March 2021, precisely when the new Biden administration came into office. So the announcements 1 year after the start of the negotiation was a very, very important step to develop the new transatlantic framework after the invalidation by the Court of Justice in the France 2 decision. We consider that the safeguards contained in the executive order address the concerns raised by the Court of Justice and bring significant improvements compared to the Privacy Shield. In short, the executive order does two things. First of all, new binding safeguards, I will come back to this, and completely new redress mechanism with the court, the Data Protection Review Court. You have to get used to this DPRC acronym, DPRC, Data Protection Review Court. So let me start by the first point, the safeguards. So the executive order creates new rules that regulate how and under which conditions US intelligence agencies can collect and use personal data transferred from the EU to the US. These rules are binding for all American intelligence agencies and ensure that any access to data will be limited to what is necessary and proportionate to protect national security. Just to give you an example, the executive order lists the legitimate objectives that can justify data collection and lays down detailed conditions for the collection, use, and sharing of data. Second point, the executive order creates a new redress mechanism. What does it mean? Any European will be able to lodge a complaint before this mechanism, free of charge, and if they consider that their personal data were unlawfully accessed by US intelligence agencies, they can have an access to this mechanism. I say mechanism because it's a multi-layers mechanism with two different parts. It's a mechanism independent and with binding authority. This is pretty new. So the first layers is the so-called CLIPO, Civil Liberties Protection Officer in the ODNI. So the CLIPO will conduct initial investigation to determine if the safeguards or other laws have been violated, and if so, determine the appropriate remediation. The second level, as I mentioned, is the so-called DPRC, Data Protection Review Court, where individuals will have the possibility to appeal the decision of the CLIPO. The Data Protection Review Court will have the power to investigate such complaints and to issue binding decisions. This court will be composed of judges chosen from outside the government. They will be appointed on the basis of specific qualification. They can only be dismissed for cause, and they cannot receive any instruction from the government. This is where we see the independence of this court. Coming back to the adoption of the new executive order and regulation, this was an important step, as I mentioned, but of course, this is not the end of the process. In particular, there is still some work to be done on US side to fully implement these safeguards. For example, the US intelligence agencies, they have to implement the executive order in their internal policies and procedures. This might take up to 1 year. Similarly, it will still take some time before the redress mechanism is set up and fully operational to receive complaints. This, of course, will have an impact on the timing for the future adequacy decision. That decision will only enter into effect once the new legal framework is fully implemented on the US side. So coming back maybe to the EU side, where are we today? So the Commission is currently preparing a draft adequacy decision based on the regulation and the executive order. We expect to be able to publish the draft decision and launch the adoption procedure soon. I will not say tomorrow, but I think that Ruth Berry didn't say tomorrow. So the process, as you know, consists of different steps. We will have first to obtain an opinion from the European Data Protection Board, the EDPB. This is the first step. Then we will need to receive a positive vote from the member states in a comitology procedure. And then, of course, the Parliament, European Parliament, will have a say because they have the draft is subject to the scrutiny of the European Parliament. So once this procedure is completed, the Commission will be able to adopt the adequacy decision. From that moment on, companies will be able to rely on this adequacy to transfer data to the US. So, as you can imagine, I cannot give you a precise date for the final adoption of the draft of the adequacy decision, but the experience we have with previous adequacy show that it could take 6 months for this adoption. What does it mean concretely? We hope to have this draft, I would say, before the summer, during the spring, before the summer. Yes, let's be optimistic. So before concluding, let me maybe come back to the significance for us of this negotiation and of this transatlantic cooperation. I have to say that we had very detailed and intense discussion with our US counterparts. And this discussion have allowed us to reach a common understanding on and solve some complex issues involving a delicate balancing between privacy rights, and national security needs. We have to acknowledge that. And this shows for us once again that on the most sensitive issues, the EU and the US can work together towards positive solutions for the benefits of the citizens and for the benefits of the business. So thank you very much. I will stop here and I'm happy to take any question you might have. Thank you.
Thank you very much for this introduction. I would like to give the opportunity to first reactions. Are there any comments or questions that you would like to raise on this?
From my side, of course, I have to say I'm pretty happy to hear your interpretation of the order and your next steps. And this really gives us hope that we will have legal certainty pretty soon. That makes really a good feeling in the morning.
Of course, also from a business perspective, we are very glad. I mean, I have to say, SAP was always running on standard contractual clauses. But we all know that there was an impact on other data transfer mechanisms as well. So even if we might not, immediately jump on the new transfer mechanism, but continue our way of operating, it still is tremendous important to us. And we're very glad, as you said, that there was that you found this delicate balance and that we found some common ground and that you believe it can work. And we will also do everything to support that.
Yes, and I'd also echo the comments and certainly relay our thanks from the US for working so hard on this, because I understand that working with the US on national security issues can often be a bit of a difficult thing to do. And from that perspective, would it be possible for you to give us a little bit of color or insight into how those negotiations went and how you perceive them?
I have to say that the negotiation, as I mentioned, started in March 2021, and Lydia Heindex had a first meeting with Secretary Levando. So we received the feedback that it took too long to have this negotiation and the finalization. But on the other hand, we had a very clear mandate from the Court of Justice. In the Schrems II decision, it was very clear what do we need to achieve. So we had to be very clear what our mandate was with our US colleague. I have to say that we had a fantastic cooperation with them. First of all, starting by video because of the COVID. This was not optimal, of course, to negotiate by VTC, but we have been to Washington, they came to Brussels, and we had intense discussion. And it's always better to be in front of, together to negotiate these. So till the very last minute, we negotiated hard because we wanted, of course, to have the best possible agreement and the cooperation with the DOC, the DOJ, or DODNI, of course, and also the NSC helped us a lot to achieve this. So what can I tell you? But we believe, I think, from both sides that we have a solid and durable solution. I think Commissioner Reinders did his best to achieve that. And voila, this is probably the maximum, the best possible result for us today in the context we know within the constitutional order, the US constitutional order, and the requirement from the Court of Justice in the Schrems too. I don't know if I replied to your question, but this is what I can tell you today.
Great, thank you.
Thank you. We also have remotely Iverna with us, and Iverna, if you can chime in, because we know that the Center for Democracy and Technology already did an assessment of the executive order, and I know that you have identified a few concerns, but also offer a number of solutions to them. Maybe you can chime into the discussion and also introduce us to your assessment that you already did.
She cannot unmute herself.
Thanks for the information.
There we go. Good morning, everybody, and thank you so much for the invitation to join you this morning, and to Madame as well for the excellent presentation. So the Centre for Democracy and Technology is a not-for-profit organisation, and we focus on protecting democracy and international human rights law in both US and EU tech law and policy, and indeed we work globally. So just to echo what was said already this morning, we deeply appreciate how challenging these negotiations were. I think even within the EU, amongst member states, national security questions can be difficult, never mind to do that on a transatlantic way. We also recognise that there have been really some exceptional step forward made with this new executive order that has been put in place, some unprecedented points. And at the same time, obviously, as an organisation working on democracy and human rights, we do indeed, as Lars had opened with, see some areas for improvement. I would just like to be very clear that our analysis is quite a factual and objective one. We really took the court ruling from the European Court of Justice step by step, and with our colleagues in the United States, we on both sides of the Atlantic, from our side and civil society, did that analysis to really look in detail about what did the European Court of Justice ask and how close does the executive order bring us. We had, and we're deeply appreciative of the challenges of that, we had called before the executive order, obviously, for Congress and other US actors to take action for more profound security reform, but we do recognise that that was politically rather unfeasible in that time. So I'm just going to run through a couple of the points that stuck out in particular for us. I'll talk a little bit to whether or not the executive order really answers the European Court of Justice standard on proportionality and necessity. Then we'll look a little bit at the redress mechanism and in particular what the court had said, of course, under the European Charter about a fair hearing and the particular elements. And we do have, which I hope will be helpful for this group and others, actually quite concrete suggestions. As was already mentioned, there is still some wriggle room, in particular with how different agencies implement this, and even maybe looking at very particular elements of the executive order that it might be feasible to tweak, just to make absolutely sure that we would obviously aim for a positive judgment by the European Court of Justice. So I won't repeat what's in the executive order. That's already been very eloquently and detail done for us already this morning. I'll go directly to the point about the proportionality test. So one of the interesting things, obviously, about the executive order is that it mentions explicitly about proportionality and necessity. And at the same time, it's clear to say this is not going to be inspired by basically either EU law or international law. And the mechanism, so I guess the legal tool of proportionality and necessity is actually borrowed from international human rights law. So we, analysing what is being taken in there, is obviously looking to say, what does the European Court of Justice, what did it say in its ruling about proportionality and necessity? It might be useful to remind ourselves initially that obviously this involves pursuing an aim that is necessary and legitimate in a democratic society and what must not go beyond what's strictly necessary to achieve that aim. So in the Schrems II judgment, the CJEU recognised the overall national intelligence aims, of course, as being legitimate, but it did state in particular that Section 702 of FISA and EO 12333 cannot be regarded as what is strictly necessary because they both adopted a more generalised approach to surveillance rather than a targeted approach. And to be lawful under EU law, they would need to have a clear scope and precise rules governing the surveillance. And so a clear risk that we see, unfortunately, is that the 12 permissible objectives of surveillance could still be determined as disproportionate because in the EO as it stands now, their breadth and the short list of permissible surveillance objectives might not actually be narrow or precise enough according to what the court has ruled. So, for example, the breadth of permissible objectives is actually illustrated by the fact that neither the White House nor the DOJ have given any indication that any surveillance practices that were happening before this executive order would actually be impermissible as a result of these new rules. So we really need more clarity on how this more effectively essentially would cabin the scope of for surveillance objectives set in the EO. So we have advised, of course, that the administration might need to clarify whether this is the case and provide greater assurance that the categories they provide a meaningful limit to the scope of surveillance. So we've also talked about the point about the scope of surveillance. So the EO specifically permits bulk collection of communications, whether it's an element of intelligence community, determines that information is necessary to advance an intelligence priority cannot be reasonably obtained by targeted collection. Again, if we look at the CJEU's case law, it's been clear that legislation requiring companies to carry out general and indiscriminate transmission of data to the security intelligence agencies for the purpose of safeguarding national security was unlawful. And indeed, in the Schrems I decision on safe harbour after degree discrimination, it said in particular legislation permitting public authorities to have access to it on a generalised basis must be regarded as compressing the ascension of the fundamental right to privacy. So this on generalised approach to surveillance and the bulk collection of data might not be delimited in a sufficiently clear and precise manner to be permitted. At the very minimum, there would definitely have to be more clarity on the procedures and rules under which the intelligence community could make that actual determination. So whilst there is language there saying that the intelligence community itself can make the determination, we definitely need stronger rules and practice to satisfy the particular case law and case law more generally of the European Court of Justice of this one in particular. In addition, the United States, in our view, might need to tighten the scope of targeted as opposed to bulk collection. So to give a concrete example, FISA Section 707, which the US regards as targeted collection program, can actually permit the collection of information about a target of surveillance rather than limiting the collection to only communications to or from that target. So that's another very concrete example. So we have, and I'm very happy to share the report with you, we have quite extensive recommendations on how we say, even within this executive order, how measures could be taken even by Congress. Obviously, there's an opportunity when there's going to be reviewing the FISA Section 702 laws, and other elements of the intelligence community agencies can actually further restrict and provide clarity on that. The other point that was extremely important, as we know, to the European Court of Justice was this whole issue of redress. And indeed, when the initial case was taken through the Irish courts, the entire, the entire case was on the EU Charter, of course, of Fundamental Rights. And I should mention, as an organisation that's also working on security and surveillance across Europe, we don't take for granted the fact that a number of European member states themselves should also look with some thought and reflection on this judgment, in particular with the restrictions on the Charter. And at the same time, from an international human rights law perspective, we don't want that to be the argument, if you like, that just because one country might not comply with such high standards that we shouldn't aim for that, of course, for all of our democracies. So indeed, this is a novel. Again, I won't describe the redress mechanism as it's been done so well. It is very important that we have a redress mechanism. This was something that was very important to the European Court and highlighted as a challenge. So it's exceptionally important that this was made. It also amounts to a remarkable ceding of authority of elements of the US intelligence community to the CPLO and the DPRC, that these entities are given authority to issue orders that bind elements that cannot be overruled by the Attorney General or the DNI. Nevertheless, we would be concerned looking in detail at the redress process for a number of reasons. One is that it's very difficult for the actual people who would take a case to be participating in it meaningfully. If a person files a complaint, they receive back the same predetermined determination that every complaint receives. They never learn why they're being subject to surveillance. If they know they had been surveilled, they wouldn't learn whether the surveillance was determined to be wrongful. If they were wrongly surveilled, they may never be told what remedy or actions would be available. So again, it's worth maybe talking about what exactly did the European Court of Justice talk about. So it talked about it as successful, if you like, redress mechanism in their view, must have the power to order stop unlawful surveillance, the power to order the deletion of information unlawfully collected, the fact-finding capability to compel disclosure of the information necessary to the exercise of powers, and the ability to receive complaints and hold fair hearings at an independent and impartial tribunal at which a complainant can be properly represented. So I would say on those first 2 points, the power to stop unlawful surveillance and the power to order deletion unlawfully obtained, we've really made progress and they can really be seen as a very positive steps. At the same time, I think where there is still definitely room for improvement in particular is around the point of a right, fair hearing and representation. So as we know, Article 47 of the Charter, which was a very key point of the Schrems, said that a person whose right has been violated has a right to effective remedy before a fair, impartial tribunal that must provide a fair hearing and the possibility of being advised. The Charter has said the possibility of being advised, defended and represented. So although the DPRC can appoint an advocate to the complainant's interests, this is a special advocate arrangement, so it really lacks the traditional hallmarks of traditional representation. So they're not chosen by the complainant. The complainant and advocate do not have attorney-client privilege or a similar confidential relationship, and they can't even directly orally communicate or confidentially. So this obviously does not preclude the complainant appointing their own lawyer, but that lawyer would not have access to the proceedings or to the information that form the basis of the DPRC's decision. So given the right to be properly represented is a key principle in the case law around Article 47 of the Charter, we think that the right for the complainant to freely choose their own lawyer is likely to be a source of controversy with the European Court of Justice. Another point that is very important would be the independence and impartiality of the body making the decisions. So obviously there are a certain number of safeguards, but the DPRC is essentially still a court established within an executive branch agency as opposed to being established by law in the judicial system. So this is obviously an attribute suggesting a lack of independence. However, its decisions are binding on the agency, which suggests sometimes of independence. So although it has definitely more independence than the predecessor or the ombuds person under the privacy shield, the CJEU will ultimately have to look at is it the case that a body of executive arm of government means that it's really capable of providing sufficiently independent judgment. Now, I know some colleagues have said, well, obviously in some member states, you might say that the data protection authorities don't meet that standard when they're making decisions. But at the same time, the GDPR, of course, has a very clear right that it does not preclude your access to a judicial review under EU law. And so that is also one of the points that we are looking at, is to say actually using existing EU law how we could actually provide an avenue in anticipation of appeals to a federal court legislation to address the state secret privilege in order to make it more likely that a decision on the merits can be reached. But also under United States law as it stands, you could have an avenue to enter a court regarding a decision made by an agency. So we'd really appeal for clarity on that, so that at very least there is an avenue to be appealed by our courts. We do feel of all, and as I said, we've got very lengthy detailed recommendations to help all these points along that I can share in the report. But I do think that the point of really meaningful legal representation is extremely important one, and that might be one, given the way US law is outlined, might require even a tweaking of the executive order, something which we don't think is impossible, because obviously we're suggesting that special advocate should be permitted to freely communicate at very minimum with the complainant, because that special advocate has got security clearance. And of course, there are lots of other people within this intelligence community in the United States who would have access when they've got that clearance, that information. So again, there's a number of particular tweaks based on the detail of the European Court of Justice that we are suggesting to make. I'll leave it there. As I said, there's a lot of technical suggestions on how to get closer to that positive judgment by the European Court of Justice, but I'll leave those comments there for today. Thank you so much.
Thank you very much. Thank you very much for your input and your insights from your assessment. I think everybody in this room will agree that we want to make this framework fly. So it needs to work, it needs to be stable, it needs to be durable, because I think everybody who is working under this framework wants to rely on this. How can we address those raised concerns that we make it happen, that it's going into that direction?
So I very much appreciate the work that CDT did, and their analysis is actually very helpful. The thing that I'll point out, and that I probably will point out more than once during this discussion, is the need to advocate for U.S. surveillance reform. And I think that is what is going to underlie and make the EO a bit more durable, right? We have Section 702 is coming up for sunsetting, and it's coming up for reauthorization. And it's something that the I2 Coalition actually works with CDT on in advocating for changes. And so I think that as someone from the US, what will be helpful from the European side is support for surveillance reform and an understanding that the US has particular surveillance needs. Those are similar to those that are going on in Europe, and kind of there's no way for me to think to describe it other than kind of an end to the finger pointing that goes on about US surveillance, kind of an understanding that it's something that needs to be dealt with in the US, but it's something that's common among industrialized democracies.
Thank you very much. And maybe, Corinna, you can also give us some details about why is it so important that we make this framework from a business perspective?
Thank you very much. I mean, I mentioned it already. For us, it's really crucial. And I think one can come up with so many examples of what would happen if you stop the transfer. I think the easiest one is in the HR space. I mean, SAP is a global company, right? Obviously, we have people in the US. I mean, if we would stop the day of those, we, for example, just couldn't pay our employees anymore. Just to give one concrete example. I think what is also important to keep in mind in this overall discussion about data flows is that not all data is the same. We're essentially a business-to-business company. We process a lot of customer data on behalf of our customers. So already there, the question starts, we would just not hand this over, right? It's a different perspective to, for example, social media, completely different. So we think it is really crucial to understand what are the different needs of the different businesses and what is, when do you move into a very, very sensitive space. And also keep in mind what companies have been doing to step up to the plate, right? I have to say that I follow the whole fall, of everything. I was already with SAP when we negotiated the GDPR. So, chapter 5, up and down international data transfers already in the law. Then I saw safe harbor falling. So Schrems 1, I saw Schrems 2, but I also experienced how, obviously there was pressure, but companies are really ready and they've done that. Stepping up to the plate, implementing, although, it shouldn't have needed Schrems 1 or 2 to make sure that you have data protection, data transfer impact assessments. Chapter 5 already demanded that you think about what is happening when you transfer data. What impact does this have on the data subject? This should not be to the detriment of the data subject. Having said that, very often transfers are also even important for the data subject. Many things, as I explained before, an employee is a data subject. So you want to see your salary paid. So that we shouldn't forget that, we present it often in a way to say, it's always to the detriment of the data subject. I don't think so. Often, when you travel, you have an interest that your data can travel with you. So in a nutshell, I think we need legal certainty, as I said, but also, to look at the different nuances of not all data is the same, not every transfer is the same. And not forget about that it's the essential lifeblood for global companies like SAP, but who are, operating in the business-to-business sphere. So again, we very much welcome the progress that was achieved, and we also welcome, the scrutiny of organizations like CBT. I think that's we have to get ready for Schrems 3, I'm afraid. Your work is very welcome, and I think it would be really important to already anticipate what's ahead of us. Thank you.
Thank you very much. I mean, it's not the intention to already put this framework under fire before it's even there. But I think we have to consider potential concerns from the very beginning, to think about, okay, how can we make this as waterproof as possible? Because this is actually what we need and what we are looking for, and to ensure legal certainty and clarity. David, you mentioned that there is this this idea that we could explain in the US what is actually needed to get a process started for surveillance reform. And can you make concrete suggestions what we can do from a European perspective?
Sure. So the first recommendation I included in my statement, and that is a recognition that that surveillance activities that are occurring in the United States that form the basis of ECJ's decision are not unique to the United States, that they take place in Europe, and they're so it is helpful for me as an advocate who is advocating for surveillance reform in the US to be able to say there's a recognition this is a legitimate activity, but here are the things that need to take place to refine it, to make it less burdensome on companies who are processing data internationally. That's what is very helpful. As an example, and I think as Corinna pointed out, The issue with Schrems 2 is not business access to data, it was government access to data. And so helping us with surveillance reform will be very key to creating an adequate privacy regime in the US, in addition to helping us support maybe a federal privacy policy, that's kind of like asking for your Christmas present and your birthday present at the same time, but that's what I'll do.
But as you just mentioned, federal legislation in the US, maybe you can also give us some information about what's the current status of legislative initiatives in the US on the federal level, but maybe also on the level of the different states.
Sure. So we were very hopeful in this last Congress that there would be federal privacy legislation. It didn't get across the plate, although it came for legislation in the US, it came relatively close. There was broad agreement. I am actually very hopeful that in this next Congress that there is an opportunity for federal privacy legislation. I think both parties are interested in it for different reasons, but sometimes when you have both parties interested in things for different reasons, they end up meeting together and ironing out the differences. The goal, of course, from the I2 Coalition's perspective, is to have federal legislation that has state preemption, right? We want a uniform privacy legislation across the US. That is going to be more difficult. So you asked about state legislation. What is occurring in the US is states are filling the void that the federal government is not and implementing their own privacy legislation. I think the standard right now that we're seeing across the country is similar to the laws in Virginia. Virginia and Colorado seem to be a bit more standard than, for example, California, which is a little bit out there, which is typical for California, right? It tends to be a little bit more strict legislation. So that's kind of where I think it's going. I would say that if the federal government doesn't step in, we're going to see 50 different sets of privacy legislation, which from a US perspective is just a nightmare. But that's what's going to happen.
Okay, and taking a look at the language of the executive order, and maybe you can also give us some idea of what's happening on the European side. Is there was a discussion in Washington about the language of the executive order. If this framework will be understandable also for small and medium-sized businesses, so that it is as easy to implement as possible. What is your view 2 months after on this?
On understanding the executive order, I think it's difficult to understand, but I think what will happen is something very similar to what we saw with the two different Department of Commerce privacy shields, and it will be reduced to a process that you can sign on to. In addition, my understanding is that the goal of the negotiators was for companies who are already signed on to current privacy shield concepts, those will continue to be applicable, which is very, very helpful as a company who has already qualified. And most of our customers are already qualified, so that will be very helpful. That makes it a bit easier.
May I ask, will this be the case? So, or will companies have to requalify under the new framework?
No, what we understand, of course, is that the principle, the privacy shield principle, will still be applicable. There will be some updates, of course, taking into account the improvement that we've made. You know that we had this annual review, so we try to integrate these updates into this, but the principle will stay the same normally. So that should be easier for the companies. But maybe I would like to react to Iverna's intervention, because I think she made a very good point. And of course, we had the same question negotiation. So probably most of your questions should be addressed to the US administration, and maybe you will do that. But for us, when we negotiated this agreement, the question was always the right balance. Do we have the good balance between private rights, as I mentioned, and national security needs? Because you know that we have case law from the Court of Justice where the court recognizes also these national security needs. In the EU legislation, in the treaty, in the GDPR, we have also some exception where we have to take into consideration these national security needs. So the question is always a balance. And where have we found a balance? By introducing these safeguards, the principle, necessity and proportionality. We can discuss about the scope of the proportionality. Is it enough or not? And we have also the safeguards giving the individual, the citizen, the possibility an access to a real redress mechanism. So for us, these are the two main elements who, for us, are solid enough to ensure that we have the right balance. But in fine, as some of us mentioned, the Court of Justice will be the only one to appreciate if this balance is fine, if the requirements of the Schrems II are met, and we can never predict what the court will say. So our understanding is that we have found a good and solid solution with this balance. But I'm happy also to discuss point by point, if you want, maybe not today, on the specific safeguards. This is really because we mentioned the previous privacy shield with the ombudsperson. This is totally different what we have now. This is not just an improvement of the ombudsperson. This is a new system with some safeguards. Of course, this is not in the judiciary branch, but in the executive one, but with some guarantees and safeguards on the way this administrative tribunal is composed. So, voilà, what I wanted to tell you, maybe to reassure you or to reassure you that we are convinced that we have found a good balance.
And I think this is really important about our attitude towards this framework, because the alternative, we talked about that, it's also pointing to HR-related topics. It's obviously not only related to internet economy, it's related to all the companies in the world actually who are part of the digital transformation right now. And we're talking about a lot of money about this digital transformation, and we want to encourage the companies, our members, but also all the other companies who are around this area of digital transformation to go further with it. And data privacy should not be the showstopper for digital transformation. And I think the framework we have, even there are a lot of things maybe have to be more precise and to be clarified, is a good one right now. So we really should look into the future, into the digital future, and go on with business and with expansion and the digital growth of the economy in this area. I think the attitude is also important, because I come from a member state in Germany. We have really different perspective on data privacy, and this doesn't make it much easy at the European Commission to get one voice from Germany. I know that, and we will really work hard for that to get a solid perspective on the framework we have right now and the opportunities which come out of these regulations right now. This is something, so let's have a positive attitude, and if Schrems III will come, the results are open. And I think this is a good situation we are in right now. Thank you.
So can I echo something that Alexander and Corinna have both said that I think is important to reinforce. Businesses are not in the business of funneling data to governments. That is not what we do and what we want to do. It's not what our customers want. And that's an important point to make. And it seems to get lost sometimes in discussions about GDPR and about surveillance. The company that I work for publishes a transparency report. It is part of our privacy policy. It's something that our customers rely on. We do not want to be in the business of providing data for surveillance. And I think that what Alexander said is very true. That is what kind of fuels this transformation.
Thank you. And I don't know if you have your hand raised, so please chime in.
Thank you. No, it's unmuted.
It's fine.
Thank you. Yeah, exactly. Just to also stress, of course, that CDT is not in the business of trying to, suspend transatlantic data flows, because that would also have huge implications for human rights and fundamental rights. It really is the question, as was said, about the need for the deeper security reform, and the fact that, it's very correct that, of course, national security is a legitimate interest, but that you just need those, in practice, that proportionality question. And indeed, I think this Section 702 sunset process that was mentioned will be a real opportunity, and we really hope that there will be enough momentum, and maybe it's an appeal to both industry and European counterparts to add to the political pressure to really make that process meaningful. And there is, like I also mentioned, there's scope for the operationalization of this, about how the different security elements and agencies actually define the scope of that. And we do, as I'd mentioned already, I mean, our organization is also working on the post-Pegasus scandal, talking about, not only the government compelling companies to hand over data, but just even without any question of consent or taking it, this phenomenon as well. And all of those different questions really point to the fact that globally in the digital age, we need to think more thoughtfully and profoundly about the safeguards that we need, proportionality and transparency. And I think it's also that question of, probably historically it was this idea that anything to do with national security has to be entirely secret and we can't know exactly what's going on. And you can see both at international level through the jurisprudence of the Human Rights Committee and obviously the European Court of Justice and other actors, that there's now realization that actually, in order to have a more predictable and legal stable environment, we'll always need an element of obviously transparency. And when transparency is not possible for security reasons, you at very minimum need to have that judicial oversight and review. And I think that's the bedrock of having a very secure legal frameworks on both sides of the Atlantic, frankly. Now, it's a whole other question when the courts are no longer totally independent in a country. That's a conversation for another day, unfortunately. But I do think indeed that that's the opportunity before us, is really to use these next months. There's 6 months. There's still more that can be done to push further towards a stable framework. And so we would obviously appeal to everyone around this table to do that. And I've shared the report in the meeting chat, and happy to do so by email more concretely what other steps could be taken. Thank you.
Thank you, Alberna. You just mentioned the global perspective, and this is also one question that I have for the panel. And if you expect that the new framework will offer the opportunity to have a global impact on other international agreements on exchange of personal data for commercial purposes.
If I may, I hope so.
Yes, please.
I hope so. I hope it will be a source of inspiration for other adequacy. Yes, of course, we hope that.
I would think so too. But what I wanted to mention as well is that this whole process, it's very cumbersome and it's certainly a challenge for companies. But I think it also helped to think globally about your data transfers as such, right? So it certainly forced companies to become more mature and think through their entire structure of data transfer. So we certainly didn't just stop, at the US borders, if you will. We constantly think about, is this really necessary? And also evaluate, of course, other countries And the topic today is the US, but let's face it, there are many, many other countries where you would not say that they're democracies, right? And where you should be extra careful to transfer data. So certainly I would say I hope that it has an impact on, also international other agreements, but I can tell you for sure that it has an impact on companies already in terms of how they think about their data transfer globally and how to secure them with contractual or technical means. Absolutely.
Thank you.
Yeah, but I think there are already some good initiatives on the way right now. If you think about Gaia X or the data spaces which are established right now, this is exactly what you mentioned right now. Be aware of your data. Think about which data has to be in which context to be transferred or has to be saved in a special way. I think this situation is actually happening right now, and this is a good sign. And thanks for supporting Gaia X and all the other initiatives around this topic.
Thank you. I don't know, is this an old hand or a new hand? I have to admit, I didn't make that. Okay. Thank you. Yes, please.
Yeah. What I wanted to add to Alexander's remark is that still, in the light of all these discussions, we should not forget that security as such doesn't stop with the data being kept locally, right? We cannot just say because it's sitting somewhere, it all of a sudden is safe. We still have to also remember that there are many other bad actors out there that are trying to get access. So by no means should we lower also the technical security measures we have in place. So I think this is also a point that we keep on forgetting sometimes in this debate, that first of all, you need to keep, you would say, your infrastructure, but your data safe. This is also really essential and something we should not lose sight of.
And if you open this field of cybersecurity, we also have to open the field of encryption, for example. And encryption is something, if you want to have your data safe against states or other areas, you don't have to go into initiatives which maybe weaken encryption in Europe or in Germany or wherever.
And there we have a new hand from.
Sorry, I don't have good visibility in which hand I'm raising at any one time, so I thought you were the one. No, I couldn't agree more with this point on encryption. Again, we're working globally and regionally, protecting investigative journalists, human rights defenders, asylum seekers, migrants, those who are very, very vulnerable. And whilst we are also very active in the area of privacy and child protection, we are deeply, deeply concerned about the Commission proposal on child sexual abuse material. We've brought it before engineers, technologists. I'm an international human rights lawyer myself. It does break end-to-end encryption. And obviously, given that the EU is traditionally such a champion of human rights and in particular protecting journalists and human rights defenders, so we're working very hard to try and to come to find different compromises that would still provide grounds, obviously, to protect children and have that that element, but at the same time not go. So, I mean, talking about proportionality would be totally disproportionate to break end encryption for the world, basically. So yeah, just to say, I think that's it's an important tool in this conversation. It's also, as we know, a very live debate in Brussels at the moment that CDT is very involved in.
Thank you. And any reactions on this? And I would like to pick up one more aspect that has been discussed in Washington, and that was the aspect if this framework also offers the opportunity to stimulate digital businesses on both sides of the Atlantic. And if there is a view in this room on this aspect. So do we have a potential for stimulus with this new framework?
Sure, absolutely. I think that anything that creates certainty and creates the ability, particularly for US businesses, to help our European customers comply with their own laws, is going to stimulate digital trade. And that's something that I don't think is businesses we talk about very much. Is it is in our business interest to create compliant structures that allow our customers to comply with their local laws, which is how GDPR impacts the US anyways. So yes, absolutely, provides a great opportunity. Anything that facilitates that is going to help business.
And just agree.
Yeah, maybe just put me some data into this discussion. The EU is talking about the value of data economy in 2018 from about 391 billion euros, increasing up to 829 billion euros in 2025. I mean, this is a stimulation package, I think.
Thank you. We are reaching the end of our panel discussion because we have a hard stop at 45. And I would like to open the floor to ask questions. If there is any question in the room or online. No? Okay.
No.
Because then I would like to open the round for my final question is, what do you expect from the next month? I don't want to mention a specific number of months, but let's say in the next half year, what do you expect as an outcome, and also in the process, what will happen that we come to a framework that's really stable and durable, and that we have legal certainty, and under which all stakeholders that are affected by this framework can work under this. Who would like to start?
But if I may, Lars.
Yes, please.
So at EU level, there will be a lot of discussion on this new framework. First of all, as I mentioned, at the EDPB, European Data Protection Board, they will discuss precisely, of course, the executive order and the regulation, but also our draft adequacy decision. There will be discussion in the Parliament, a lot of discussion in the European Parliament and the member states too. So I would say that now the discussion will be on the EU side. So we'll have also to explain, to reach out, to try to communicate as clearly as possible on what we try to achieve, so that this is the start of a long process for us. We are prepared for that, but this is only the beginning of the story on our side. And if we can count on you also to. No, but that's important to explain what is it and why we do that. So that's an important part. And finally, the adoption, hopefully, as I said, spring or before the summer.
Or to phrase it differently, how can we contribute to this process to make it successful?
But I would say that this kind of event that we have today, this kind of roundtable, help for the understanding of what is being prepared. But we will be able, of course, to say more about our drafts in the coming days and weeks. So maybe another roundtable would be useful. I never hesitate to ask for that. Our colleagues from DG Justice are also very happy to discuss and to explain. So yes, that could be helpful to have another round, maybe a bit later.
Yeah.
Thank you.
Thank you.
Yeah, I can also say that we are never getting tired of reminding also in our discussions. I mean, obviously we also have a lot of discussions for a company like SAP. It's our national territory is Germany, and I can tell you that we have a lot of discussions with Mr. Calver and also the National Data Protection Authority. So we are never getting tired of reminding them how important it is, to first of all, to have data flows, but also for companies like us to have legal certainty and not to be forced to pick, like, what legal framework do you want to infringe, So we really like to see this being concluded and while again, we don't see, us in the business to business sphere in the center of the hurricane, right? But we are on the sidelines, and we still try to explain why it's important, but also again, what additional safeguards we can bring to the table. So you can also be sure that we will be part of the discussion going forward in the next month.
Thank you, David.
So from my perspective, what's going to happen in the next 6 months is we're going to be holding our breath, right? Hoping that all of the hard work that the negotiators did to get to this point is successful. I am happy to jump on a plane and have more roundtables if that's what's helpful. I agree that it is good to keep the pressure on. What I would offer is not only in the next 6 months, but in the next year and a half, folks should help us in the US, as we advocate for meaningful surveillance reform, which I think is something that needs to continually be reinforced, that this is the problem that the ECJ is identifying. There is an opportunity in the US to do something about it. I'm not as informed in how feasible that is with this next Congress, but it is always a possibility. So in the next year and a half, that would be very helpful as well.
Thank you. Ivona, would you like to chime in with a final remark?
Just thank you all very much for the invitation, joining you this morning, and for all of the thoughtful remarks, etc. And obviously, our final call would be, please do, we put a lot of thought and time on both sides of the Atlantic from our way in what ways we can push this further forward. And we welcome those who are interested in further discussions. And to answer the initial call, we absolutely have advocates working very hard in the corridors of Congress and the White House and other places to implement these measures, and all support would be welcome in that regard. Thank you.
Thank you.
From my side, I mean, the DNA of the internet is international, and data economy is essential for our future. So I think we have now a framework which is really worth to be getting realized, and we will support you from the member state level, from the EU level, with rounds like that, but also in bilateral talks we have now to follow up. This is something I can promise you from ECO, the Association of the Internet Industry. Thank you.
Thank you. I couldn't phrase it better, so I leave it with that. Thank you, everybody, for joining. Thank you, everybody, for attending online. Thank you to all of our speakers for joining this panel this early hour. Thank you very much. And this meeting is adjourned. Thank you.
Thank you.
Thank you for the great moderation.